we'll get everyone started here. So hi, everyone. Welcome to Proper Steps of a Legal Termination. Today is sponsored by your Central Valley Regional HR Hotline, which you'll hear about in just a second. My name is Anna Manzano. I'm the Digital Media and Event Strategist here at the California Employers Association. Before we officially kick off today's webinar, I have just a couple details to go over with you. So as you see, your audio is going to be muted for today's presentation, but there will be lots of opportunities to engage during the session. Thank you for already being so active in the chat today. Love to see it. If you have any questions pertaining to the content, you can type them right into the chat box at any time. If they end up in Q&A, that's fine. I'll be here helping monitor with Mary and making sure that all of your questions get answered today. Handouts for this training were sent out in yesterday's reminder email. However, I'm also going to drop the PDF into the chat in just a minute or so. Once you see the file pop up, if you need to still get that PDF, just click on it and it'll download locally. Feel free to message me if you have any trouble. Last but not least, we do have a survey. It's 5 questions. It takes less than 90 seconds. But the feedback that you provide with us, we then share with our partners over at Central Valley. And collectively, we just make sure that we are meeting your expectations, hopefully exceeding them, and providing you with a suite of resources, including virtual trainings like this, to help you run your businesses and departments with more peace of mind. So if you could take the minute at the end, we would greatly appreciate that. Okay, so now I have the great privilege of introducing our trainer today. We have Mary Bradford, one of our amazing HR directors, who if you have called the hotline, maybe you have spoken with her. And I know we have so much to cover, so Mary, it is all yours.
Great. Thank you so much, Anna, and welcome everyone. So glad that you are able to take an hour out of your busy HR days to join us to talk about proper steps of a legal termination. First of all, I know we have lots of people from all over the Central Valley, and glad that you're all with us from beautiful Yosemite up to the north in Placer County, where I am located. Glad that you're all here, but you all have access to this amazing, no cost to you hotline. So this is something that's being provided by the various counties and workforce development boards. So we really encourage you to take advantage and give us a call Monday through Friday, 8 to 5. Just make sure you kind of reference this slide. Anna always has a great suggestion that you just screenshot the slide and kind of keep it on your desktop. And then depending on what your county or what county you're located in, just give us a call on that county number. And we would be more than happy to help you out with all of your HR issues. If it's a follow-up termination question to today, if it's something about hiring, if it's about a leave of absence or the ever-changing and moving wage and hour in California, feel free to give us a call anytime. And I was going to say, if anyone has a burning question that they want to make sure I try to cover today, go ahead and drop that in the chat box as well, because I want to make sure I answer as many of your questions as I can. But if there's something you're thinking, oh, I really hope she asks or answers this, go ahead and drop it in the chat box, and I will make sure by the end of today we cover that. So let's go ahead and get into how CEA can help you through the HR hotline, and then what you're going to need to do to stay compliant in California. Now, for those of you that aren't familiar with CEA, I know maybe you've called us on the hotline, maybe this is the first time you've heard about us, or maybe you are one of our members, but we are the California Employers Association, and our job is to try to bring you peace of mind in dealing with California compliance issues. So we do that through lots of training. Hopefully you've joined us for other trainings, and you'll join us for future trainings from the hotline. But we also have a wide range of other trainings that are available to you that you are always welcome to attend, even if you don't have an individual CEA membership. So I encourage you, take a look at our website, that's employers.org, and you can sign up for any of those trainings that you would like to. We'd love to have you join us. We talk about all different topics, all the HR essentials that you need to know, as well as workplace violence and other plans that you need to have for the workplace. So check out our website, lots of resources out there, and our newsletters out there, our blog is out there. So lots of good ways to keep you up to date with HR things. The other thing I do want to remind everyone, we are not a law firm. So when you call CEA on the hotline, or when you're listening to me today, we're not giving you legal advice. So we always recommend you have an attorney that you can consult if you ever do have a matter of legal significance. Not a bad idea in California just to have an attorney available. If you ever need an attorney, we have great partners that you are always welcome to call, and those are all available on our partner page on our website. So I hope you never do need them, but if you do, they are there to help you out. So here's what we're going to cover today in the next less than an hour. We're going to talk about why documentation is so important and why you want to make sure you've got a good paper trail to protect you. We're going to talk about how coaching and discipline really work together, because I do want to remind everyone how important it is to coach as well as document before we get to that termination step, whenever that is feasible. And then we're going to talk about really what do you need to do to avoid any legal problems when it's time to end that employment relationship. So let's talk about employee documentation, but more importantly, we want to talk about proper employee documentation and why it's so important to have that. So there's all different types of documentation you might have. If you joined us for one of our seminars on hiring, for example, we talk about how important it is to have job descriptions, because we see job descriptions as life cycle documents, your employment life cycle document, where we talk about what we're looking for, and we use that job description for our ad. And then we use that job description when we're interviewing someone, and then we end up using that job description if we need to performance manage someone because they're not meeting the requirements of the job description. And that is one of those job expectation things. You want to make sure it's well documented. What are the expectations of the job? What does anyone need to do in this job to be successful? You also want that to go hand in hand with your employee handbook, where we talk about what are the values of our company? What are the guidelines that we want our employees to follow as far as professional conduct, as far as harassment prevention, as far as attendance? All of those things fall under those values and those kind of our rules, our guidelines, and our policies. And then we also want to make sure we are very clear when it comes to documentation, what employees need to do to change a situation. So if you're writing someone up, and I'll give you an example in just a little bit, we want to make sure we're saying to the employee, this is what's been going wrong. Here's what you need to do to make it better. But if you don't improve and if you don't change, here's the potential next step, which is normally going to be a statement, something to the effect of, there may be additional disciplinary action up to and including termination. So you're telling employees, here's what's going wrong. Here's what you need to change. Here's what will happen if you don't change that behavior. So we want to make sure we've got as much of that documentation as we can. So why do we need to document? Again, this is really for your protection. And as an employer in California, we'll talk about at-will in a little bit. I know a lot of times people like to say, well, I'm just an at-will employer. Can I terminate anyone when I want to? Technically, yes, you can. But if you want to limit that potential exposure of making a bad decision when it comes to a termination, it's much better to have some documentation that shows you as the employer were trying to do everything you could to save this relationship. And you were giving this employee opportunities to correct their behavior, giving them a chance to know that there's something going wrong and that they need to improve upon it. So that's that, detailing those expectations. Hey, something's going wrong. We need to make some improvement. It also will show a history. And that is often a good defense for an employer, where you can show, and this is why I recommend in documentation, when you go to write somebody up, you can even say, we discussed in February your attendance. It is now May and we're continuing to have attendance issues. Specifically, you have missed these days over the past 3 months. Again, that's showing that you've got specific example and we have a pattern of problems or attendance issues that have been occurring. And again, it also is going to show that evidence to help protect you as an employer, that you're making decisions based on objective facts. This is based on the job description. This is based on what anyone in this position is supposed to do. And this is why we had to make this decision. So it really takes some of the emotion out of it. It takes some of that subjectiveness out of it so that you can be very clear and concise. Now, as far as other general documentation, it does also help protect you in that it shows why employees perhaps were demoted, why they might have got a salary increase or a promotion. So again, you want to have that objective paper trail so you can show why you were making these decisions and why they really made sense. So how do we want to document? I know a lot of times people will call on the hotline and they'll talk about a performance issue, and I'll say, okay, well, what sort of documentation do you have, or have you talked to the employee? And they'll say, oh, I've talked to the employee so often, but I guess I've never really written anything down. The reality is, if you didn't write it down, it probably didn't happen in the eyes of the law or in the eyes of somebody who's looking out from the outside. So it's really important that we start formally documenting these things. Now, as far as what sort of documentation, maybe it's just a email that is sending a follow-up email to an employee when you're talking about an attendance issue, when you're coaching through an attendance issue. Or maybe it's actually a formal written warning that you sign and the employee signs. So there's all different types of documentation. But whatever sort of documentation you're using, you want to, again, be able to show that trail that we talked about it, and I asked them to improve it. They didn't improve it. We've had continuing issues, therefore I'm writing them up again. You want to make sure when it comes to your documentation, again, it's very objective. We're going to talk in just a second about bad documentation, but you want it to be objective, fact-based. And there's something in California called using good faith and fair dealing. And that really means you as an employer were trying to do things in good faith and you were trying to be fair. And if you put together objective, fact-based documentation, that's a very good argument in your favor that you are trying to be very fair. The other thing to keep in mind, as I always think it's a great idea, anytime before you need to write somebody up, anything that you're putting in writing, if it's a performance review, if it's a final written warning, if you're about to put somebody on unpaid suspension, whatever it is, take a step back and look at it from fresh eyes and pretend that you're in a courtroom when that thing is blown up on the wall in front of a judge and a jury. What would somebody think if they were looking at that? Would they think it's fair and it's honest, or would they think it's kind of snappy and snide and it's wrapped up in emotion? So let's talk about some of those examples with bad documentation. You want to avoid writing things that are opinions, that are labels that are just kind of these general statements. So I have some examples for you here. Saying somebody is irresponsible, or saying somebody is not very nice, or they're lazy. What does that mean? You really want to be able to be a little more specific. Instead of saying somebody is irresponsible, what you want to say is, the weekly reports are due into our accounts receivable department by noon on Friday. Mary has been late 3 of the last 4 weeks. That's much more clear in how they were irresponsible, as opposed to just saying, oh, they're irresponsible, or they're too slow, or they're too lazy. So we want to make sure, again, we're sticking to those facts and we're giving those specific examples. We also don't want to kind of cast our own emotions or our own feelings on somebody. We don't want to say something like, you know, it looks like they're over their head on this project, or I guess they didn't like this assignment. That should never be in a write-up. What you would have in a write-up is, Paula was given this assignment on May 1st. It was due on May 20th. It wasn't turned in until May 25th. It was 5 days late. That's what we want to take a look at. Not they didn't like doing it or they didn't think it was fair. We want to, again, stick to all of those facts. Be careful about the words you use. Again, be very objective with that. Pretend a jury's looking at it. And oftentimes when you go back and read it, when you have it with a different perspective, you kind of go, oh, I wouldn't want a jury looking at that or a judge looking at that. So again, you're going to make sure it's factual, it's objective, it is complete. And again, you want to be consistent in all of your write-ups. So when it comes to proper documentation, it's going to describe the issue. It's going to describe policy that's been violated, which is why we always encourage you to have an employee handbook so you can cite specific policies. That helps you as a manager so that you remember what the policies are, and it also helps your other managers be consistent. That's another reminder for you. Make sure everyone is on the same page. When do we write somebody up for this? When is it 3 tardies, or is it 3 late assignments before somebody gets written up? Because you want to make sure people are being consistent. Because if one manager is writing their group up after 1 misstep and another manager's not writing their group up until there's been 5 mistakes or 5 late assignments, that's when you're looking at inconsistency. So make sure your organization is on the same page as well. You also want to make sure you are very clear. So you want to say, here's the issue, here's what had happened with those specific dates, here's what needs to improve, and then what are the outcomes or what are the next steps if these things don't change. It's also a great idea to have a follow-up meeting where you can say, excuse me, we'll discuss this again in 30 days, or we'll meet on the week of July 1st to follow up with this discussion. But again, all of these things should be documented one way or another, depending on where you are kind of in that coaching or documentation process. Again, this could be a follow-up email, or maybe this is something you're going to include in that written warning. But we have to write these things down because you are all so busy. There's so many things going on. You will forget. You'll absolutely forget. Were they late 3 times in May, or was it just one time? Gosh, I can't remember. It was such a busy month. We had that big production run. We had all those customers coming in, whatever it is. It's hard to remember that stuff. You're all so busy. So make sure you're writing it down. Make it easier on yourself. So when it comes to what supervisors need to do, you have to make sure you've got that well-documented practice where you are saying, this happened, that's a violation of this policy, this is what's going to happen if it happens again, it has to improve by this date. So again, you want to be consistent, but you also want to engage employees. Whenever you're having a coaching discussion, performance discussion, it should really be a two-way dialogue, because you might find out that there are other things going on. Maybe they planned on having that report to you every Friday at noon, but maybe somebody else wasn't getting them the information that they need. So you might have another issue going on. So I always recommend, I know it's really tempting because probably by the time you're writing somebody up, you're pretty frustrated and you just want to tell them what they're doing wrong and move on. But if you are the only one doing the talking, you might miss out on some important things. You also might find better ways to do things. They might say, I know we do the reports this way. It's just that they take about 6 hours to do that. I think I found a way where we can do it in 3 hours. So again, you want to have that discussion. So just make sure it's not you are the only person talking. It's a two-way dialogue. And they might say to you, you're right, I'm late all the time. I oversleep. I really don't like this job, whatever it is. But at least you're giving them the opportunity to tell their side of the story, so that you have that information and you can feel even more confident about those decisions that you're making. As I mentioned before, you have to be consistent. You need to be consistent in documenting coaching as well as disciplinary action. Now, when it comes to coaching, some of that documentation might be your own internal documentation that you just keep for yourself. So maybe it's, I spoke with Mike Monday morning at 11 a.m. The report was supposed to be in at 10 a.m. I spoke with him at 11. He said he was waiting for one thing and then he would have it for me. And then he did indeed turn it into me at 11:30. So that's just something that you're checking on. And then you're going to say to Mike, hey, I want to remind you, if you can't have that done by 11, I need you to contact me because I'm expecting it by 11. So that's a coaching session. That doesn't necessarily need to be a formal write-up, but that's something you want to capture, because if that happens again next Monday, you want to be able to look back at your notes and say, gosh, I already talked to Mike about that. And he didn't give me that report until 12. And he didn't tell me it was going to be late. And I told him last week he needed to let me know if it's not going to be done by 11. So again, it's just kind of that reminder for you. I did talk with him about this, and this is what I said, and this is what we agreed to. So it just helps you out too. And then, of course, we need to be aware coaching and disciplinary actions protect everyone's rights. So it protects you as an employer, and that you're saying to an individual, this is a problem, this needs to change. And it's also protecting the employee so that they're aware that there is something that's not going right and they need to make some improvements too. And leaders also coach constantly. ABC, always be coaching. So make sure if it's coaching, if it's corrective action, you are telling the employee something's not going right. We need to make some changes. Again, it's verbal, it's a written warning, whatever it is, it should always be ongoing. So what do we do about those employees who are unwilling or unable, right? They are causing problems and they're just not making a difference. Well, that's why all the documentation we've been talking about is just so important, because it shows the employee and shows the world, if you're ever questioned, we talked about this, this is what was expected of them. They knew they were supposed to do it and they didn't change. They didn't improve that performance. It again shows that good faith and fair dealing. That shows you as an employer, we are trying to improve things, but the employee, it's ultimately up to them. And they did not improve it. Therefore, we had to go down this next step of disciplinary action or termination or whatever it is. And again, that reasonable standard. Remember, we want to make sure we are holding all employees to the same standards. If everybody has the same job, those same expectations need to be met by everybody, which means you also need to be consistent in writing anyone up who is not meeting those standards. Don't make the mistake of you have employee A who you just love and they're wonderful and you really like him as a person. Employee B drives you crazy. They're both not meeting the standards. They both need to be written up. Don't make the mistake of not writing up one person because you like them more and then writing someone else up. That will inevitably go down a discriminatory claim path. So you have to make sure that you are being consistent and holding everyone to that same standard. So let's take an example here. This can sometimes happen too in workplaces, especially those of you that might be taking on a new HR role, or maybe you've got a company that's merging with another company. Sometimes you inherit employees, or if you're changed or promoted into roles. So we have Carol, who is a 61-year-old diet tech. She has had positive performance reviews for 20 years, and then a new supervisor comes in. The new supervisor says Carol is making all sorts of mistakes in preparing menus for patients, and then said Carol is not competent and has to accept another position, take a severance package, or be discharged. The employee sues the company for age discrimination, and she wins her case. Now, a couple of things to look at here. First of all, we've got some protected categories. Carol is 61, so anyone over 40 is a protected category at the federal and state level. So we've got somebody over 40, so something we need to look out for. Now, we also have positive performance reviews for 20 years. All of a sudden, somebody comes in and says she's horrible and she's not competent. Well, this is where we need to take a step back. Sometimes performance reviews are not accurate, and perhaps Carol is incompetent. But if after 20 years of glowing reviews, someone comes in all of a sudden and says, "That's it, you're fired, you're horrible," that's going to look like quite a red flag, and attorneys are going to love that. So does that mean that Carol can't be fired? Not necessarily. But what it means is we need to take a step back and see, is there any documentation? Maybe we need to start some documentation before we go right to transferring or terminating someone. So we need to be very careful with this, because as the case shows, this particular case sued for age discrimination and won. If they had had proper documentation, if they had taken those proper steps, chances are she would not have sued, or even if she had sued, probably would not have won. So that's why we have to make sure, again, we've got that paper trail, we've got that consistency, so we're being careful with those things. So let's talk about punctuality, because I know so many of you are dealing with this and it gets really, really frustrating. So we have Holly, who's been late for her shift multiple times this month. So 2 weeks ago, she was 10 minutes late. Today, she's 15 minutes late. As soon as you start to notice that pattern, you want to address it right away. Now, we all have bad days. We all have kiddos that might have delayed us getting into work, or traffic, those kind of things. That happens. But when it starts to happen more often, or especially 2 times in 2 weeks, that sounds like we're starting to have a problem. So what do we need to do? We need to coach and clarify. So we say to Holly, hey, as a reminder, your shift starts at 8 a.m. We expect you here at 8 a.m. If you can't be here at 8 a.m., we need to know why, and we need to know when to expect you. Now, we want to ask her again, her side of the story. What happened? Maybe there was an accident. Maybe there was something that was beyond her control. But again, it's a two-way dialogue. So we want to find out what's going on. Then we need to talk about, how are we going to improve this? Are you able to be here at 8 a.m.? Is there something that's preventing you from? Now, this is where you might want to consider, is this something that you can be flexible on? If she says, I have to drop my kids off every day, the drop-off line is horrible, maybe you can have an agreement. Well, we could have you work 8:15 to 5:15, if that's something that might work for your business. If that won't work for your business, then you can stick with that 8 o'clock time, because that's what the shift needs to be. But this is, again, where you want to have that two-way dialogue. Maybe there is an opportunity for flexibility. Either way, you're going to document the issue, you're going to talk about what those expectations are, and you're going to say further tardiness or further attendance issue can result in additional disciplinary action, up to and including termination. So we still keep having problems with Holly. So she's late again for the 3rd time, 20 minutes late. So it's getting later and later. So we're going to sit down with her and we're going to talk again. But this time, probably a good idea to have a written warning. And that's, again, why you want to make sure you documented everything that happened in that first discussion so you can reference that in the written warning. And that's why in the written warning, you could say, we met last week, you had already been late 2 days, and you list those specific dates and the specific time that she was late, the 15 minutes and the 10 minutes. And then you say, and today you were late again. And then you want to be really clear. There can be no more punctuality issues in the next month. And then that next step, I always recommend when you've got that formal documentation, and this should also be in everybody's handbook, you have a general statement that additional disciplinary action up to and including termination for violation of any policy. That gives you that flexibility. Maybe I'm going to write you up another time. Maybe I'm going to have to terminate you. But that's not locking you into saying you will be written up again, or you will be written up 2 more times before you are terminated. Gives you a little more flexibility. Now, again, offer encouragement, but it's ultimately up to them, especially when it comes to attendance issues. So you can say, if you have any concerns, come and talk with me, but we do expect you to be here every day at 8 a.m. So what if the employee refuses to sign the written documentation? A lot of times employees won't sign it because they think it doesn't exist if they don't sign it. They are incorrect. So what you want to say to them is, you're not required to sign it, but your signature just acknowledges that we've had this discussion. But if you don't want to sign it, that's fine. I will be making a note that we met at 11 a.m. on the 25th, and you did not sign this document, and it is going in your personnel file. So let employees know this is still going in your file, even if you refuse to sign it. All right, so back to Holly. So she's late again. Oh, Holly. So she's late for the 4th time. So we have, again, all of this pattern. And now this is the decision. You get to decide what you want to do. You get to decide as a management team or as the owner of the company, how many times are we going to write people up when they are late 4 times in the past 2 to 3 weeks? What's your decision? And that really is where you have options. Am I going to write her up again? Or are we going to need to move to that next step, which is going to be termination? So if you've ever joined us for one of our hiring seminars, we always say hire slow, fire fast. The reason you want to fire fast is because you should have done everything up to that point to prepare for needing to end that employment relationship. So that means that you have written somebody up, you've coached them, you've talked about that performance, you've given them opportunities to change, and you've reminded them what the policy is, and they are still continuing not to do it. Now, let me give you another example of why fire fast is so important. So Jane has been insubordinate and is instigating arguments. She's causing a lot of problems in the workplace. Jane's supervisor, David, decided it's time to terminate her. He goes and he speaks to HR about that decision on Monday, and they decide, well, let's have her finish out this week and we will terminate it on Friday. Unfortunately, David only spoke to HR in person, and there's no paper trail of their decision to terminate this employee on Friday. In the middle of the week, Jane comes in and says she has to take a leave due to a medical condition. I'm sure, as all of you already know, if you terminate somebody a day or 2 after they tell you they're taking a leave of absence for a medical condition, that may not work out very well for you. So in this particular situation, they've never disciplined her. There's nothing in writing. They don't have any sort of documentation saying that we've got a performance problem. David only spoke to HR and it wasn't written down. Nothing was documented as far as that decision. That's going to be a real problem. It's definitely looking at some liability because all of that performance was undocumented. It's going to look retaliatory. It's going to be a discrimination for a medical condition, leave of absence, which is very protected in California. So that's why we have to make sure when you make a decision to fire somebody, probably best practice is to fire them as quickly as possible. If you wait a week, or if you wait a couple of weeks, or until the end of the quarter, that may come back to cause you some more problems. So that's why we always encourage, when it's time to fire, it's probably time just to fire. Now, of course, you still want to work with HR or upper management or whoever is appropriate for your organization to make sure you've got all of your ducks in a row, all the documentation has been done, and you feel comfortable about that decision. But usually, if you want to make that decision, it's better to make that decision as quickly as possible. Now, you might be saying, well, she's a real problem. Can I still fire her. Possibly you can. And that's also, if you ever call the HR hotline, we will always say, it is absolutely up to you. It is your decision. We are just giving you some options and information so that you can make the most informed decision. But it's probably something you'd want to talk to an attorney about to get a legal opinion on it and see what they really think once they have all of that information. Anytime that there's a protected class that's involved, there's a little more exposure for you as a business, and we never want anyone to have to go down the road of litigation. So anything you can do to mitigate that is always in your best interest. But there are a couple of options. The thing to keep in mind, if you have a problem employee and all of a sudden they have to go out on a protected leave and you're worried about terminating them because they're on a protected leave, which is wise, the chances are when they come back, they'll probably still be an issue too, because just because somebody went on a leave doesn't mean they're going to come back as the best employee you've ever had. If they were a problem before, most likely they're going to be a problem when they return. So you can take a look at, well, let's write them up when they get back, because they'll probably be doing the same things. Or maybe you need to start documenting that performance. If they say, I need to take a leave in a couple of weeks, well, then maybe you need to sit down and have a discussion, well documented with objective facts about what's not been going well before that leave starts, and say, well, we've had some performance concerns. We'd like to discuss these with you. Of course, we're granting your leave. You're able to go out, but these will be in effect when you return from your leave as well. So you can have that discussion. Also, another option, if you decide you do need to terminate someone, maybe you want to come up with a severance agreement. We always recommend and encourage you to work with an attorney on a severance agreement. Severance agreements have gone through a lot of changes in the past couple of years in California. And so you always want to have that executed by an attorney so they can have the most up-to-date language and make sure that they're really taking a look for you just to make sure you're as protected as you can be when it comes to severance agreements. There's also a lot of different rules for severance agreements based on somebody's age, how much time they have to sign an agreement, how long they can rescind that agreement, even if they sign it. So you want to make sure you're always working with an attorney. So let's talk about those 3 important steps for a lawful termination. You want to make sure the reason for termination doesn't violate the law. So again, you don't want it to be discriminatory. You don't want it to be retaliatory. You want to make sure it's not violating the law when you're terminating somebody. You also have to determine the type of separation. Is this a discharge? Is this a voluntary quit? Is this a retirement? What exactly is it? Reduction in force. You need to make sure you know which kind it is. And then again, paperwork. As we've talked a lot about, having a paper trail is very important. But when it comes time to termination, there's a lot of forms that you need to provide to your employees as well. So we'll talk about those. So another reminder about at-will employment. Again, we encourage everyone to have an employee handbook. One of your first policies in your handbook should be your at-will statement, which basically says either the employee or the employer can change the terms and conditions of the employment relationship at any time, with or without cause, with or without notice. So that is kind of a general at-will statement. You want to make sure you have your at-will statement in your handbook, as well as your applications, as well as any other documentation you have, because you don't want an employee getting the idea that they are under some sort of contractual obligation to work for you forever, or that they get to work for you forever. Now, you want to remember also that there are a lot of protections, whistleblowers specifically in California. I know that's kind of been in the news lately. Whistleblowers are very protected, but also employees are protected if they file a complaint, if they go to the EEOC and say harassment has occurred in the workplace, if they go to the DLSE, which is the Division of Labor Standards Enforcement, or the Labor Commissioner, and they make a wage claim. You want to make sure that we never terminate someone because they went and filed a claim or are participating in some sort of protected activity. Be very careful about that, because at will, we are an at-will employer, but again, we can't ever terminate somebody for protected activity or for a discriminatory reason. So sometimes employers will say, well, we're at will, we're just going to terminate them, we'll be fine. Not necessarily. So you always want to be careful and just be aware of that. So let's talk about our step 1, making sure the termination is lawful. So what are some lawful reasons? A violation of policies, Again, another reminder to have your employee handbook so you can be consistent when somebody's violating a policy, poor work performance, reduction in force, someone being dishonest, conflicts of interest. Be careful with that because there are protections in California that employees can have other jobs while they're working for you. But there can be situations if they are taking proprietary information, for example, that might be grounds for termination or separating the employment relationship. Remember, in California, there's no such thing as 3 strikes and you're out. You do not have to write somebody up 3 times. Sometimes you don't write someone up 1 time, you just terminate them. If you have some sort of serious offense, if there's violence in the workplace, if somebody brings a weapon to work, you're certainly not going to write somebody up 3 times. You're going to want to be able to terminate them right away. So that's why you want to make sure in your handbook and your policy, you don't have any language, for example, progressive discipline, or we sometimes call it lockstep disciplinary procedures. You want to make sure you have a policy that doesn't say, first you'll receive a coaching discussion, then you will receive a verbal warning, then you will receive an initial written warning, then you will receive a final written warning. You are locking yourself into doing that. So make sure your policy doesn't say that we will follow these 4 steps before we terminate. You want to give yourself that flexibility. Use the all-important word may that we like to use in HR. We may write you up for a violation of policy, but it gives you that flexibility. So don't lock yourself into those progressive steps. Also, probationary periods do not exist in California. So if you have that language in your handbook, get rid of that as well. There's no such thing as probation in California because we are an at-will employer, and you don't want to imply that someone is guaranteed a job for 90 days and then they could be terminated within that 90 days without an issue. Because again, you always have to be careful anytime you're terminating an employee. You also want to make sure in your handbook you specify who can change that at-will relationship. It's normally the president, the owner, kind of the highest level of the organization, because you want to make sure that other lower level managers aren't promising somebody a job for 5 years or anything like that. Now, of course, if you're a union organization, if you're under a CBA or an MOU, different rules apply, so always defer to those. All right, document, as if we haven't talked about documentation enough, right? But this is a reminder. We want to be able to show our employees they were aware of the issue, they knew they had to change it, and they didn't change it. That's the importance of documentation, those 3 steps. We want to make sure that we tell employees what the rules are. That's why we give employee handbooks out upon hire. When they violate a policy, we're going to tell them that they have violated a policy and we're going to give them a warning, whatever type of warning that is for your organization. They know what the consequences are and they need to improve it. So that's really the documentation that we're looking for. We want to be able to show they knew it was a problem, and then they haven't changed it. Therefore, we're going down that termination path. So the types of separation, again, resignation, somebody just resigns, they say they're leaving your organization. Perhaps they are refusing to accept available work. That can be grounds for termination. Job abandonment, be careful with this one. Make sure a lot of businesses will have a 3-day no-call, no-show policy. That is perfectly fine to have. But remember, if an employee is utilizing paid sick leave, remember in California now, paid sick leave is 5 days or 40 hours. For full-time, part-time, everybody can be eligible for that much time. If somebody is utilizing paid sick leave, you don't want to take any adverse action against them. Again, other types of separation, termination, discharge, layoff. That's all when you, the employer, are the moving party, and that's really what you want to determine. If it's a voluntary resignation, the employee is the moving party. If it's a termination, discharge, or layoff, then the employer is the moving party. Let's talk about conducting those final meetings. We never do it in public. We never try to embarrass an employee, humiliate them. We want to make sure we are always holding ourselves to very high standards, very professional, and we make sure we have a lot of dignity because these things can be very emotional. They can be very difficult. We want to make sure we're not sending mixed messages. We don't want to project our feelings onto the employee, trying to make them feel better by making us feel better. We don't want to do that. I know these things are so uncomfortable. I've had to do it many times in my HR career. It's never easy, even if it's an employee who's been a problem and they've had performance issues, whatever it is never easy to terminate somebody. but you want to make sure that you always hold yourself up to a very, very high standard. So here is the right way to fire. A lot of times people ask, what time of the day is the best time to fire somebody? There is not a good time to fire somebody because it's never a great time to have to fire somebody. But what I always recommend is do it when it is the least disruptive to the organization, to the department, to the location, however you're dealing with it and ending that relationship. Maybe it's first thing in the morning, maybe it's last thing at the end of the day, but do it whenever it's going to be the least disruptive to everybody. So when it comes time to schedule that call or that meeting, that in-person meeting, you want to be very clear. Let's meet today at 2 o'clock. And again, as we talked about before, we're not going to shift it and say, gosh, I'm so sorry, I wouldn't have done this. This decision wasn't up to me. If you're the one giving the message, you want to make sure, again, you're very professional, you're going to use your empathy, and you're going to say to them, we have some information that we need to discuss. We've talked about your attendance issue, or you have violated this specific policy. Therefore, you are being terminated effective immediately. And let's go over the final paperwork. These should be very short, very sweet meetings. Also, we never recommend, sometimes employers want to put together a termination memo where they kind of outline how the relationship started and what went wrong, and now that it's ending. We don't recommend that. All of that should have been done before, when you were writing your employees up as part of your discipline practice. And so by the time you get to termination, it's really just telling them that they're being terminated and going over that final paperwork. Now, why it's important to fire someone correctly and with respect and professionalism, because when you do it the right way, only employers or only employees sue their employers about 1% of the time. It's a very, very low percentage. When employees are not treated well and they're embarrassed or humiliated, or the person firing them is just a jerk, they end up suing employers about 19% of the time. So we want to keep those numbers low. We want to make sure, again, we always hold ourselves to a very high standard. When it comes to the termination paperwork that's required, if you know from hiring employees in California, I think we're up to 15 different new hire forms that are required now, at least. Luckily, there's only 3 when it comes to termination, but you do want to make sure you're giving your employees all of those pieces of paperwork that you're required to give them. So the first is something called the Notice to Employee as to Change in Relationship. That is a long title for a very simple form that either says they are being discharged, it's a voluntary quit, or it's a layoff. And that's all you have to say to an employee. You don't have to go into any detail. Like I said, that memo, don't put together a memo. We don't advise it. It's just a simple one of those 3 reasons why an individual is being terminated. You also have to give to every employee, voluntary or involuntary termination, that EDD for your benefit pamphlet. That's that little blue pamphlet. You can just download it from the internet as well. It is several pages, but that includes information on filing for unemployment. So you have to give that to everyone, even if they have voluntarily resigned. Everyone gets that form. And then you have to give them something called the HIP form. That is the Health Insurance Premium Payment Form. Now that, a lot of times people say, well, I don't have to give that. We don't even offer medical benefits. It's not anything to do with COBRA. It's to do with Medi-Cal in California. So all employees are required to get that. So those top 3 bullets, every single employee gets those forms regardless of their termination reason. And then if you do offer benefits, then of course you're going to need to make sure that you are providing them with COBRA information. A lot of times your carrier will do that for you, but if you do that, make sure that you are providing any appropriate COBRA forms within the appropriate timeline. And then of course, the number 1 most important thing is that final paycheck. When you tell someone that they are being terminated, when you say those words, you are going to provide them with their final paycheck. That's going to include all wages worked through that day, any accrued and unused vacation or PTO, any bonuses that have been earned through that date that are due upon termination. Those all need to be paid out at that time. Now, for those of you that are CEA members, we do have a great termination checklist on the website that has all of these listed, as well as links to those forms. So do make sure you're utilizing that. A couple of questions we often get when it comes to final paycheck rules. Can I withhold a final paycheck? Say, for example, my employee has a laptop and an iPhone that we've issued to them. and they aren't turning it in. So I want to hold their final paycheck until they turn those things in. I would love to tell you that you can withhold their final paycheck. You cannot withhold the final paycheck in California. So all wages are due to an employee. Again, when you notify them that they are being terminated, you don't want to withhold any wages. You don't want to deduct any wages from final paychecks. We simply don't advise it. So if somebody has something they haven't returned to you, if it's a uniform or a laptop or anything, you want to tell them what it is that they need to return to you. You can also give them the opportunity to purchase that item. You can have your accounting person figure out what the value is and say, you're welcome to keep that laptop. It's now worth $400. You can write us a personal check for it. But again, don't withhold any wages. If people have something of value, a work truck, for example, that they're not returning to you, which happened with one of our members recently, then they potentially have stolen property that they need to return. So you may need to contact the authorities. But if somebody owes you money, for example, say, for example, you have fronted them a week of vacation or 2 weeks of vacation, and they owe you that money, you want to create, again, an invoice for them to say, you owe us this amount of money. We have, paid you this extra or this loan that we've given you, whatever it is. Ask for them to pay it back. If they don't do that, you can always take them to small claims court. So when it comes to commissions or expense reimbursements, there's some good news for you as an employer. You do not have to pay those out upon termination, but you do need to pay those out on the next regular payout of those. So if you pay out expense reimbursements on the first of every month, you can wait until the first of the following month to pay out the employee any expense reimbursements they're due. For commission plans, remember, you're required to have a written commission plan in California. Make sure that commission plan is very clear as to when commissions are earned and when they are to be paid out. So pay at termination, as I mentioned before, that needs to be a live check. Do not do a direct deposit on a final check. Really should be a live check that needs to be paid at the employee's primary work location. And remember, as I said, when you're the moving party, when you're the one ending that employment relationship, you have to have a check that you hand to them when you say those words. Now, if the employee is the one who is resigning, so they are voluntarily resigning, if they give you at least 72 hours notice, so say, for example, they come in on Monday and they say Friday's my last day, they have given you 72 hours notice, you want to make sure you've got that final paycheck on your last day. If they just walk in and quit, then you have 72 hours notice from the time they quit to get them that final paycheck. Now, keep in mind, that is 72 clock hours. And so that means if somebody resigns on Thursday at 4 p.m., that means by Sunday at 4 p.m., you need to have that final paycheck. So it does include weekends. So we always recommend anytime when it comes to final pay, make sure that you are just being very timely with that. Always, of course, if you're the moving party and ending that relationship, it should be given to them right then. But even if they are the ones that are resigning, it's better to just get that check to them as soon as possible so you don't have to worry about there ever being a delay of any type. Now, as a reminder, accrued and unused vacation, as well as PTO. If you have your vacation and your paid sick leave lumped into a PTO or a paid time off plan, that all has to be paid out upon termination. Now, if an employee voluntarily quits and they just say, that's it, I'm out of here, and they go AWOL on you and they say, mail my final paycheck, that's perfectly fine. But you do want to get their final permission and you want them to tell you where they would like it mailed. So it's great to get that in writing, ideally with their signature that says mail it to this address, and they sign off in some way. If it's a screenshot, perfectly fine, but it would be great to get their signature on that just so there aren't any delays when it comes to getting that final paycheck to them. So this is what a wage statement should look like in California these days. There's quite a lot that needs to be on there. So you've got this in your notes. Just make sure, take a screenshot of this, share it with your payroll company, just to make sure all of these things, this is on every single pay stub, not just your final pay stub, but make sure all of this information is included. Oftentimes we find that these things are missing, especially if it's a payroll company that maybe not as familiar with some of California requirements. There's a lot that has to be on there. All right, what I was telling you how important it is to make sure you pay all those wages when they're due, and here is why. Employees can file wage claims with the DLSE, and that's the Labor Commissioner, the Division of Labor Standards Enforcement, for 3 years, going back 3 years. If you don't pay your employees everything they're due upon termination, you can be subject to what are known as waiting time penalties, which is 1 day of pay for up to 30 calendar days of that employee, what they would usually make. You can have to pay them 30 extra days. There's also interest and other penalties that can be on top of that. The Labor Commissioner can assess additional penalties if they so choose, and the employee has 4 years to file a claim. That's why we always recommend hold on to your payroll records for at least 4 years post termination in case anyone ever does file a wage claim. And of course, we always pay minimum wage in California. Right now, the state of California is $16 an hour. Make sure you're always paying that. More than 40 cities or counties have their own minimum wage, so make sure you're paying the appropriate minimum wage where your employees are working, because it gets quite pricey if you don't. Now, how do we share the news with other employees when someone has been terminated? We, again, always make sure we're very professional, we are discreet, we don't give any information that we don't need to give out. And honestly, what most other employees want to know is, how is this going to affect me? That's really what they want to know. So what you want to do is, again, you're not going to share any specifics. You're simply going to say, Mike is no longer working for our company. This will impact some employees. We'll be meeting with them today to let them know some work that they might need to take on, but we will be, perhaps you're going to say, refilling that position, or we will be opening this position up to internal candidates that want to apply to it. Or you might say, this position has been eliminated. We have figured out how to disperse the work over 2 different departments. We'll be meeting with those departments to talk about new responsibilities. So those are the things you want to just let them know how it is going to affect them, how their duties or responsibilities might shift. So be very clear about that. But again, we don't want to share any information. You know, they were fired for this, this, or this. You don't want to share that. You could say they were violated for, or excuse me, they were terminated for violating the company policy, but you don't need to go into any details. So less is more in those situations. All right, I want to see if we have some questions that I can get to here before we wrap it all up. Let's see if there's a couple in here. So let's see. The first, okay, back to when I was talking about probationary periods. So the first 90 days of continuous employment is considered an introductory period. So sometimes it comes down to semantics, and I would just encourage everyone to be cautious on the words that you use. Because keep in mind, in California, it doesn't matter if somebody is terminated on the 90th day or the 900th day. They can still be eligible for unemployment. They can still file worker comp claims. So those days don't really matter. If you want to call it an introductory period in regards to, we'll meet on the 90th day to evaluate your performance, that's fine. But sometimes employers think, well, if I fire them on day 85, nothing will go wrong because they haven't been here 90 days. So that's what you want to be careful of. Also, sometimes employers will say, oh, okay, there's a probationary period of 90 days. Sometimes employees are really great for about 91 days, and then it starts to go really downhill. So normally what we advise is that you have a 30, 60, 90-day check-in, and just to kind of check in with the employee to see how things are going. But just be careful how you're using that language. Now, of course, you can always have a 90-day waiting period, for example, before somebody can utilize their paid sick leave on their 90th day, or benefits don't start until the first of the month following 60 days of employment. Those are all perfectly fine, but just be careful that it's not really probationary period in disguise, is what I would say. And Anna put into the chat box, thank you so much, Anna, termination checklist. So you can access that there. Let's see. And so we had another question about if an employee owns the company money, you can't take money from their final paycheck. We do not advise it. When it comes to final pay, we always recommend pay employees what they are owed and then seek other ways to get any money that is owed to them. So small claims court, maybe you get an attorney involved who can send them a letter, but just don't take any deductions. Labor Commissioner can sometimes get a little cranky about that. If an employee resigns and they ask for a deposit within the timeline, is that okay? Probably, but what we have been told is best practice is to get a separate direct deposit form sign off. So a sign off specifically for that final paycheck. Again, I would just advise having really good documentation on that. You might want to talk with your CPA or bookkeeper because they might be a little more familiar with some of those guidelines or best practices for that. What if an employee emails you a resignation letter after hours? Employees never do that. Happens all the time. If an employee emails you a resignation after hours and you cannot contact them, how would you pay them? Direct deposit or mail a check? Great question. So if an employee emails you a resignation letter, you can't get a hold of them. That often happens. They mysteriously disappeared. What I would recommend is that you then respond back to them via email to say, we've received your resignation. We will have your final paycheck within 72 hours or whatever day, if you want to say by Thursday or by tomorrow. It will be available for you at your place of work, wherever that was, at the office, or if they were at a different location. And that's available for you to pick up during normal business hours. If you would like us to mail it to you, please put that in writing with the address you would like us to send it to and sign that document and take a screenshot of it. And then that's your documentation that they said it was okay to mail it. I would just never recommend automatically mailing a final paycheck because things get lost, they get misplaced. And then I would hate for you to be on the hook for any waiting time penalties of not getting that final paycheck to them in a timely manner. Do you recommend not allowing an employee to go back to their desk once you do an involuntary resignation or layoff? That is the tricky one. It all depends on the situation. If you feel it's going to be contentious or a potential violent situation, then no. If you think it's okay, I would always have someone escort them. And again, do it with as much dignity and professionalism as you can to make sure that it is handled in the right way. But oftentimes employees just want to leave and you can say to them, we will be happy to box everything up and we can send it to your house. Or if you want to come pick it up, if you feel comfortable with that. So you've got a couple of options though. What if a term date falls on a direct deposit date? Do you still need a live check? Yes, you do. You still want to have that live check when you are terminating somebody. Let's see, what if you were advised by legal counsel that you can mail the check if the employee declines to answer and you do so and you do it overnight? I would never go against what your attorney would say, so I would always defer to your counsel, of course. I would just be cautious and make sure that you're able to track any checks. But again, if your attorney has advised you to do something else, I would always defer from them. And let's see. Not all employees who quit, especially via email or text, will answer. Yes, I know sometimes it can be very difficult when somebody quits. Oftentimes they have started a new job or they have moved and they won't tell you that they have moved. But yeah, I know it can be very difficult to track somebody down. Anna also popped in our next training for Central Valley into the chat box. We would love to have you join us for that. If you have a question that you want to ask that you would rather not ask in front of everybody, please just give us a call on the hotline right after this call. We will be happy to help you out with that. Let's see, can you give further explanation as to why for final checks? Go ahead if you have a specific question on those final checks, just give us a call on the hotline because I know we are right at our time and I don't want to keep anybody past, but my goodness, excellent questions, everybody. I really, really appreciate that. All right, so let me leave you with a couple of words of wisdom here. Remember, you've got to always be prepared that an employment relationship might end. And when it does end, we do it with professionalism, we do it with grace, we do it with kindness. It's never a great thing, but sometimes it simply has to end. And we try to end it on the most positive note that we can. So again, your wrap up, document your little hearts out. Give us a call on the hotline if you have questions about how best to document. You want to always be coaching, be clear, be honest, and just be upfront with your employees so they know what to expect. And of course, as we talked about, accurate final paychecks are so important. Here are those numbers again for you. We've got that membership information. If you find out you need a little more help, we're always happy to help you above and beyond the hotline. You've got your HRCI codes 660224 for HRCI and SHRM 24-XAE6P. So screenshot those, and those are for if you have your PHR, SPHR through SHRM or HRCI. If you want to get an hour credit for today, we certainly want you to get that credit. All right, with that, I will put the survey back on. Sorry, Anna, I got a little chatty and went over, but thank you everyone so much, and give us a call on the hotline. We always love chatting with you, and have a great rest of your day. Back to you, Anna.
No apology needed. I'm so glad that so many questions got answered. It was like speed round with you. You're amazing. And yeah, like Mary said, I can't stress it enough. I really hope that you utilize that Central Valley HR hotline. There's a whole list of numbers, so make sure you consult that PDF that we gave you, or hopefully you took a screenshot, or just call or email us, and we'll make sure that we get you to the right person. But again, on the screen, you'll see a QR code. It also should pop up in a browser window after this, but we really encourage you to provide us with some feedback. If you would like to see more trainings like this, please let us know. And we really do hope to see you at the next training in June. Also, it's bringing wellness to the workplace, so a very important topic right now. And enjoy your day. Thank you, Mary, for sharing your expertise, and we hope to see you calling into that hotline soon. Enjoy. Thank you.